you submit that if there is a single subject violation with regard to any of these bills, they all go down?
I would say that if there's a single subject violation with regard to the omnibus, 9634, then the omnibus goes down, and certainly the appropriation bill goes down because it's tied to the omnibus. In the very language of the omnibus and the appropriation bills, it says that if one goes down, the other goes down. I'd also say that in practicality, 9637, what the legislature called the Budget Implementation Act, or the BIMP, it would go down as well. And it would go down because it largely retraces many of the provisions in the omnibus. It changes the implementation of the tax dates. It has a series of its own special problems in that it creates a consumer protection provision for consumers who deal with rental car companies, completely unrelated to this purpose. And when it goes back over the ground of so many provisions that are in the omnibus, 9634, then it falls because of those as well. Those provisions cover the map: operation spending, capital spending, as well as these numerous other things we've cited that are really rather small things, probably designed to get individual votes.
Mr. Vinson, would it be difficult for a capital bill of this magnitude to ever be passed that would not be in violation of single subject?
Well, in 1971, I believe, there was a substantial transportation bill passed that this court approved, Ogilvy versus Lewis. Now, it confined itself to bonding and bonding provisions and to making the money available. And in Cutinello, in I think 1991, you approved another very major transportation program that you upheld on single subject, and it confined itself to raising taxes for transportation and distributing the money to transportation agencies. Yes, I think it can be done. I think you can pass a bill that raises the taxes. I think you can pass a second bill that creates the projects. I think you can pass a third bill that does the appropriations. I don't think you have to tie those things together. I recognize that there were spatial circumstances that surrounded the passage of this bill. The governor had been impeached and removed. A new governor had taken office. It may well be that elements of trust were missing across the street that would typically be in place. And because of that, perhaps people wanted to be able to vote not just for the taxes, but for the projects at the same time. And they wanted provisions in the bills that guaranteed everything to them. But I'd submit to you, very respectfully, Your Honor, that the most disastrous thing that can occur in our society is not that a particular program be delayed, and it can certainly be recovered by the legislature repassing the thing with curative legislation overnight. And in fact, there is curative legislation that's passed the Senate, it's in the House, and it's out of House committee in a substantive committee. Probably if you were to rule from the bench today on these bills, you'd see legislation pass by Memorial Day that solved most of these problems. But I'd submit that there is a much more substantial issue at stake here, and that is that the single subject rule, the appropriations, the no substantive language in appropriations, those kinds of rules are so fundamental to making the legislature and our society operate appropriately that the bigger catastrophe would be for the court to skimp on the enforcement of those rules. When you tell the legislature they need to do these things, they do them. They do them carefully. And it's not a case of you having to intervene and go over there and vote and police the legislature. It's a case of you finding exorbitant examples of legislative convenience. And convenience isn't the best way to run the legislature or to run government or to run a society. Constitutions are.
May I ask this question? If we were to disagree with you, if we were to find that this set of bills do not violate the single subject rule, what happens next?
Well, I would certainly hope that you would find that it violates the substantive language in appropriation bills and throw the package out on that basis. And if you didn't do that, I would certainly hope that you would find that the liquor tax is not uniform, because the state has not survived the burden shift in the liquor tax.
So you believe that then we would have to go forward and address the other issues that were raised in the proposed complaint?
I believe that you should, yes.
Would a factual record be necessary to resolve the uniformity challenge, since this was really decided on the basis of whether leave should be granted to file the complaint?
What's happened in the uniformity case at this stage is this. The legislature raised the tax on beer 4.6 cents a gallon. And it's actually not a tax on beer. It's a tax on the occupation of distributing beer. They raised the tax on the occupation of distributing wine 60 cents a gallon. And they raised the tax on the occupation of distributing spirits $4.05 a gallon. We allege those are vastly disproportionate taxes, and that those taxes are inappropriate and don't meet the standard. And the standard is, everybody knows, is that there have to be clear differences amongst both the subjects and the objects of taxation in this kind of taxation.
So we could decide that based upon...
Satisfied its burden shift under the uniformity process. When we allege and the state defends, and the state has said here that its defense is that this is for temperance purposes, the state hasn't satisfied its defense because you have said in Wexler versus Wirtz that there is no assumption of pass-through to the consumer in this liquor tax. If there's no pass-through to the consumer, there's no impact on the consumer. And if there's no impact on the consumer, there certainly cannot be a temperance effect.
If there are no further questions, your time has expired. Thank you.